How to know if you will pay or receive spousal maintenance. When married couples divorce, spousal maintenance is an important issue that must be considered. It is also commonly known as alimony in other states. It is financial support provided by one spouse to the other, usually in the form of monthly payments following a divorce. These payments help the receiving spouse achieve self-support. There is no particular formula to calculate it, therefore it is extremely important to obtain legal advice before going through a divorce. Amount and duration are two key components in the spousal maintenance award. Generally, depending upon other factors, if one spouse has the ability to pay and the other spouse needs support, a court can award either temporary or permanent spousal maintenance. Temporary spousal maintenance is also known as rehabilitative maintenance. It is awarded for a specific amount of time to help the receiving spouse obtain education, training, or other skills to rehabilitate their earning capacity. This temporary support allows a spouse who is unable to support himself or herself financially during the marriage to become financially independent after the divorce. Permanent spousal maintenance is awarded for an indefinite amount of time. This is usually done when there is a long-term marriage of 20 years or more, when one spouse is capable of providing financial support and when one spouse is incapable of support. It is based on what he or she earned during the marriage. A court will look at several factors when setting the spousal maintenance amount. In regard to the spouse requesting the maintenance, a court will look at their financial resources, including property, the ability to meet needs independently, the probability of completing education or training given age and skills, and the probability of becoming fully or partially self-supporting given age or skills. Also, the time necessary to acquire education or training for employment, lost earnings, seniority, retirement benefits, and other employment opportunities foregone during the marriage, and the age and physical and emotional condition. A court will also look at other issues, including the standard of living established during the marriage, the duration of the marriage, if one spouse is a homemaker, how long they have been out of the workforce, and whether their skills or education are outdated. Also, the ability of one spouse to meet their own needs along with those of the spouse requesting the spousal maintenance, the contribution of each spouse in acquiring property, and the contribution of each spouse in the appreciation in the value of the property. A court will not, however, take into account any allegation of marital misconduct. Spouses can agree to waive spousal maintenance altogether. This means that the spouses agree they do not need financial support from one another. If a spouse waives spousal maintenance, they are unable to return to court at a later date and requesting maintenance no matter the circumstance. A waiver should only be done after obtaining legal advice. In some cases, a spouse may decide to waive spousal maintenance in exchange for a favorable property award. Spousal maintenance is taxable income as well. The person paying spousal maintenance to his or her former spouse can deduct spousal maintenance for his or her tax purposes. Likewise, the person receiving spousal maintenance must add the maintenance award to his or her income for tax purposes. When thinking about spousal maintenance, tax consequences must be taken into account, so be sure to ask your attorney. If spousal maintenance is an issue in your case, you should consult an attorney that is experienced in family law for any legal advice. So please know your facts. You can't afford to miss the free divorce fact pack at www.allaboutdivorcemn.com.